Good afternoon, everybody, and welcome to today's webinar. I'm Barry, a Senior Product Specialist here at LawPath. Today, we'll be going through protecting your intellectual property in 2026. Thank you to everyone who's joined and popped their locations in the comments. It's great to have you here. Saw someone from New Zealand as well as here in Australia. So welcome on board. We will be recording this webinar and it will be put on our YouTube channel. So if you miss any of the slides or want a recap of any of the information, it will be available shortly on our YouTube channel. Just a little bit about LawPath. We are an online legal and accounting platform. We have been in operation for a little over 10 years now. We have helped over 500,000 small businesses in Australia get set up and with ongoing support. We've saved over $500 million in legal fees, and we've had over 10,000 five-star reviews during our time. We are here to help small businesses with their legal, accounting, and tax needs all in one single platform. We can provide all of your legal documents, contract management, virtual office, and basic compliance services, business registrations, as well as a full suite of legal, accounting, and tax solutions. This allows you to get everything done under one roof for your business. I'll introduce our our lawyer who will be joining us shortly. Our lawyer is Christopher Heaton. He is a consulting lawyer here at LawPath. He has over 15 years of experience in commercial, technology, and IP law. He's a former top tier and Big Four lawyer with international experience, so you can trust what he's saying when it comes to IP and commercial and technology law. He specializes in IP commercialization, transactions, and risk management, and he's known for giving very clear, practical advice for growing businesses. The topics we will be covering today will be how trademarks protect your business name and brand, what copyright protects automatically and what it doesn't, when NDAs actually work and when they don't, how contracts determine who owns the IP, and key IP risks in the AI and online environment. We'll also have a live Q&A at the end of the session as well, so feel free to pop your questions into the chat as we're going. Chris will answer some of them throughout, and we'll cover the rest of them towards the end of the webinar there as well. Why this matters to your business. So ideas drive value. Your brand, content, products, and system are often your most valuable assets. Making assumptions are risky. Many businesses assume that their IP just belongs to them legally. That's quite often wrong. Your IP can be used by other people if it's not protected correctly. Early protection also wins. Fixing your IP issues early is far cheaper than disputes or rebranding later. So it's better to be more proactive with this than reactive in the long run and also in the short run. I will let you know as well if you do want to have a call around this. Please type yes in the chat. I'll be able to give you a call, kind of walk through what we do, how we can help with this all here as well, and go through any kind of questions you may have from a high level aspect. I'll now pass over to Chris, who will be able to walk you through everything here, give you the information you need, everything like that. And yeah, I'll let Chris take over.
Thanks, Barry. Hi, everybody. Welcome. Thanks for joining today. I'm very passionate about intellectual property. I find it absolutely fascinating, and trademarks are actually a really fun and very practical area that you can work on very early in your business to ensure that you protect your identity. I mean, for all your ideas and hard work, your business only succeeds if people know what it's called, where they can find you, and can associate your good work with some kind of a symbol or identity which sticks with you and you can control. To give you an idea of just how important this is, your IP, and particularly your trademark, would probably be the most valuable thing in your business. Google's trademark, the word Google, is worth $50 billion. It is the single most valuable asset in their entire business. Why? Because brand recognition. That's what customers know and trust. Now, we're going to go through some very practical examples of how to get one, what they are, what they don't do, and bust through some of these myths about trademarks, because there's a lot of things out there which really misrepresent what a trademark is and what they actually do. So look, fundamentally, a trademark, it's just a legal protection, something you register, that protects the way you describe your business, whether that's a sign, a symbol, a color, a sound, a tagline. And if you think about really famous trademarks like the Qantas Red Kangaroo or the Toyota Jump, which is a movement, movements can be trademarked, or a sound, they instantly make you think about the brand, what it offers, and your feelings about it. Trademarks are quite emotive because predominantly they're visual. You can say all the things you like about your business through reviews or other types of marketing, but that symbol or sign is going to be probably the single most important way you connect with your customers. Now, in terms of how they work, when you're at school and everyone says, best in, first in, best dressed, get in first. Well, here is something in life where it actually matters. If you get in first and register your trademark, you have won, which is why it's so important to do it so early on during your business life cycle. So if we look at the things that you might be looking to do, you've got your domain name, everyone's online. You've got all the content on your website, got all that sorted, that's fine. You've got your business name registered on ASIC and you've got your company name. They're not your trademark. They don't protect you at all. They're just the words you use to register your business. But a trademark is something you do through IP Australia. That's the government body that registers and has a giant list of all the registered trademarks in Australia. All the countries in the world have a similar registry. They're part of a very famous treaty from the 1940s called the Madrid Protocol. And those countries cooperate to share their trademark lists. So you can register in one country and enjoy the protection for your trademark in other markets or other countries through a United Nations treaty. Now, in terms of Gancar, think about words you use to describe things like a warm heater or a strawberry drink, purely descriptive, or just the word Australia. You can't trademark things that are so obvious and so distinctive in everyday language that people need to use them just to describe things like a chair or a car. But you certainly can trademark a particular brand name for a car. Like if you think of all the different cars and their fancy names, they can be trademarked. If you think about soft drinks, like Coca-Cola, they can be trademarked. They just have to be distinctive enough that people wouldn't be confused. And in terms of getting there first, it's about priority. If you register that trademark and someone tries to register that exact same mark the next day, too bad, you beat them. Yes, it does take a long time for the government to process trademarks. It's about 7 months. But the good news is from the moment that you've applied and you've put in that application and paid your very small registration fee, even if someone else tries to contest that afterwards, you'll get it first. So speed is important. You're talking to investors, you're about to launch. Oh, what about that trademark? Get it in. It doesn't cost very much. It's very cost effective and it's very important. And use it or lose it. Now, what happens if someone else already has that name? And we'll just go to the next slide. Thanks, Barry. What about a great idea that can't get very far because someone else got there first? Now, they might have a trademark in a completely different industry. I've got many clients who have trademarks in cosmetics, agriculture, entertainment, and they say, hey, Chris, don't worry. I know about another competitor who's got a trademark, but they're in the hospitality industry. They're a restaurant or a cafe, or maybe they're completely unrelated to me. Well, what I would say is think about how big the fish is, how little the fish is. If you're going up against Burberry or Louis Vuitton, it doesn't matter whether your name of the business is for a lawn mowing company, does it? Louis Vuitton and Burberry are not going to tolerate that. They're going to come after you and they're going to say it's confusing. So make sure you do these searches because you don't want to have to be fighting off someone else later on or getting caught out, being sued, or potentially have an infringement claim made against you. So Due diligence, searching is easy. Searching is free. You can do it online. We'll have some tips at the end of this session about the types of websites you can go to, both within Australia and internationally, for you to do a bit of a check and see, what if I try this? Now, words and symbols. Absolutely. Some trademarks are just what we would call a picture or an image. Some are just a word. There's two types of trademarks you can choose from. We'll just go to the next slide. The first one is just the word. So Nike, just the word. They've also got a little tick, the symbol. They combine those together and they've got trademarks on both. The first is called a word mark. You own that word in your industry. And the second one is called a logo mark. Word marks are harder to get because words are more commonly used. And if they don't have colors or symbols or anything else around them, you're basically saying, hey, I control that word in my market. If you can't get a word mark, don't worry. You'll probably still be able to get a logo mark. Let's say you're a builder or in the construction industry and you have a picture of a house and you have the name of your building company. You couldn't get the name because it was too common. Let's say it was something like Sunshine Homes or something like that. Just a very bright, very positive. Someone else has got that. But they don't have Sunshine Homes with a little picture of a house or a little picture of a family or something like that. So there's still hope. So don't worry if you think, all those words are so commonly used in my industry, Chris. How could I differentiate myself? That's really hard. Well, there's always the logo mark. So we've got here the common branding mistakes, of course. If you create it, you think you own it, don't you? What if it was done for you by a designer? Or you bought it online, or you got ChatGPT or AI to produce it for you? That's where we move into copyright, which we'll talk about later. But the main thing is, assuming it was yours, as in it was created for you, you paid for it, and you were given permission to use it, so you bought it, the IP was transferred to you, you're the owner, you can absolutely trademark it. You can sell that trademark to someone else, like when you sell your business. You can license it to people if you're a franchise and you want other people to use your brand, and that's how you get paid, through licensing. So it's an asset like anything else. You can rent it, you can sell it, you can buy trademarks, you can do deals, just like any other part of your business. All right, let's go to the next slide. Now, there are obviously some things that can't be trademarked, and the Australian government has a whole list. Things around the coat of arms, ANZAC, for example, things which might be deemed offensive or contrary to the public interest. There's a whole list. But the good news is they're the things that you can't use to name your business anyway. So if you're trying to put your business name in ASIC, you're trying to register, and you tried one of those words, they'll already tell you you can't use it. And they're the exact same words from the same list that's used for trademarks. But in terms of how many trademarks do you need? Well, there's no real answer to that, as many as you like. You might have different colors and symbols for products that you have. So you might have a series of trademarks that are similar enough, but have something distinctive based on the type of customer or geography that you're targeting. So you can absolutely bundle those all up into a trademark portfolio, and you can manage them. You might use one more regularly than the others. You might have certain signs or symbols that you use at certain types of events or activities that you do. You may slightly tweak them and modernize them every now and then. Absolutely fine. I have clients that have 50, 60 trademarks because they have very complex, large businesses, but they still take the time to make sure that they've done their homework and that those brands fit together and are complementary. So your business name is one thing, your company name is another. The next step, I think is the most important step, is brand security through a trademark. And it only takes 1 or 2 days to get your application in and do it. All right, next slide. Copyright. Copyright's my favorite because it is one of the oldest laws in existence. It comes from the United Kingdom, the 15th century, during the invention of the printing press. And the reasons it's important is because when things started being printed and published, people, well, they wanted to be rewarded for their work. Authors, novelists, they all wanted a way to be paid. But of course, once it was out there, anyone could copy it, anyone could say it was theirs, anyone could use it. So they came up with a concept of property law for ideas or the expression of those ideas. Now, copyright lasts for 70 years after the author's death. So if you sent me your manuscript and I was a publisher and I published your book, you would own the copyright for 70 years after you died. It could pass down to your family members, to your heirs, to your children, grandchildren. And that's what happened with the story of Peter Pan. Peter Pan was actually published in the UK, and the author left the rights to the copyright to a children's hospital. They actually donated it. And that hospital uses the rights from Peter Pan, which it sells for productions of Peter Pan all around the world, to fund a whole network of children's hospitals, which is pretty cool. But in any event, in terms of copyright, as I said, it's the written form of ideas. So it's words on a page, it's a sound of music, it's a picture that you've painted. It's not the idea itself. And here's an example. Einstein's theory of relativity. He doesn't own the idea. It's like Newton's theory of gravity. You can't own the idea, but you can own the expression of that idea. His paper, which he won a Nobel Prize for, absolutely copyrighted. And copyright doesn't need to be registered. It manifests immediately upon creation. The moment it leaves your head and you write it onto paper, it's automatically copyrighted. Don't need to go and see government. Don't need to register it. It is instant. You don't even need to put a little C copyright symbol on it, which everyone thinks they do. You don't. It's instant. Now, you might say, that's great, Einstein had a great idea, but, I see it everywhere. It's in textbooks. It's online. It's on Wikipedia. Like everyone's like cutting and dicing it, taking bits of it and reusing it, sitting in AI. Absolutely, you can. And you wouldn't want someone to control an idea, would you? Because that would be very anti-competitive and also quite destructive to society. You want good ideas to get out there, but you want the authors or the owners to receive a reward. And there's two ways that they can do that. The first is to be paid for their authorship or their inspiration, the creative spark. The second one's called moral rights, and that is the right to be attributed as the author or the creator. Some people, particularly novelists, it's actually more important for them to be attributed as the creator. That's what means most to them, that it was theirs, or say a painter, that it was their work. They're not as concerned about necessarily making money. Others, it's the other way around. I'm here to make as much money as I can, and I don't even care who thinks it was made. Let's go to the next slide. Now, you've got businesses, haven't you? And you've got employees, you've got contractors. They bring you something. They've prepared a report for you. They've prepared an ad. They've created your website. Who owns all this? You know how I said that whoever writes it and puts it in a form of expression is automatically the owner. Well, what if they're working for someone else? Or what if the product isn't actually theirs, wasn't intended to be theirs? Got a little chat here that's popped up that says, graphic designers. So absolutely, if you've commissioned as a graphic designer to produce a piece of art or a concept or even someone's trademark logo, you own it as soon as you created it. But someone paid you for that, didn't they? So they want to own it. So how do we get the ownership from you, the graphic designer, to the customer? Well, we're certainly not going to give it to them unless they've paid. That's the first thing. That's why we have a contract. But in that contract, we can say that the copyright is transferred to the buyer under certain conditions, like they've paid and done the other things we required. Or we can decide to keep it and say, you know what? I want to sell this to many people, not just one. So instead of selling my copyright, I'm going to license it. I'm going to give thousands of people permission to use it under certain circumstances, as long as they don't copy it and say it's theirs, as long as they don't pretend they made it, or as long as they don't destroy it, as in completely change what I've said. If that's the case, I'll license it to them for a smaller fee, and I'll make a lot of money through volume. And that's licensing, the same you see in a book, the same you see with any type of digital product, software, source code. You license it to someone to use it under certain conditions without giving away the copyright. Now, of course, a lot of founders and owners of businesses, they think that because it was their idea, it's theirs. And they tell people about it. They tell them about their idea, or they'll send them a document with their concept or what they're going to do. Let's go to the next page. And sometimes they forget that they didn't identify themselves as the owner and they didn't protect it. It's out in the open and anyone can use it. They put it online. They gave it to someone who passed it on to their biggest competitor. Now, I'm not talking about price lists or product designs or things like that. I'm talking about literally anything, an email, a text message. What do we do to lock this up? And you can see these are some of these assumptions people make, isn't it? It's like, oh, I just got it for free. It was out there in the open. I found it online. I downloaded it. I put it on my website. They promised me that they'll keep that confidential. Gosh, look, all I'm doing is publishing a copy of a really old book like Dracula, which is their author's been dead for 200 years, Bram Stoker. So how can it be copyright if it's expired? These are all big assumptions people make, which can be quite costly. Let's go to the next one. Okay, as I said, it's all in the contract. Now that contract can be real simple. It can be bundled into your supplier contract. It can be bundled into your terms and conditions on your website. And it can cover things like, hey, my employee who's an engineer or my employee who's a designer, say you're an architectural business, produced this fantastic design that's popular with customers. They did it at home in their garage, came to work and said, oh, this is actually mine. No, you're an employee and your employment contract says any ideas you have, whether they're in the shower, in the car, at home or at work, that are produced in the course of your employment are mine, the employer. I own them, including the moral rights. You've waived them. You can't sell moral rights, but you can waive them. So that's your employment contract. Your contract with suppliers, they design a product for you and give it to you. And you say, hey, I want to control this. Your contract would say, hey, I'm getting not just the license, I literally own this. You are assigning, which is just a fancy legal word for transferring ownership to me. And I can do what I want. I can modify it, adapt it, reproduce it, commercialize it, reverse engineer it. Depends what I can negotiate and what I want to do. Now, someone might say, hey, I changed it. It's different. It's not your idea. I changed that line or I moved that wall. And people go, oh, it was moved by 5% or 20%. Total myths, total lies. Doesn't matter. If it's substantially the same, if it's based on your design and it's very clear that only the most simple or basic things have changed, it's absolutely yours. But if it is fundamentally a new thing, and let's say a story or a movie like Star Wars, if you think about the battle between good and evil, if you think about those characters, you could almost put them in any type of setting or period in history, couldn't you really? The script has their names and their lines, but really, if you just swapped out who those characters were and the setting, that story would be different, wouldn't it? No, it wouldn't. You can still control the patterns, the interactions, beyond just literally what a character says on screen. So we've got a question here about an architect, and we're talking about, potentially someone repurposing or stealing their design, saying that they slightly change it. You're more than likely going to win, but it's very costly and it's very difficult if you don't have necessarily those really clear contractual protections and reinforcing to people, no, that's mine. If you give it to them and say, just use it, that's fine. If you don't constantly reiterate your rights, you can potentially be seen to waive them. All right, let's go to the next one. Now, this is how you protect that idea at the start. NDAs, you're interviewing an employee. You're going to do a pitch for a customer. You're taking your idea, you're going to put your software up there and you're going to give them a demo. You're going to show them something that's yours before they've committed to buy it as part of that customer life cycle and onboarding. You might have a non-disclosure agreement. You might say, hey, I'm going to show you some things of mine which are pretty important to me. That could be the formula to my recipe. They could be the way I do my business works, the methods I use, or it could physically be an object or an item that isn't at market yet, that's being tested. A non-disclosure agreement is is a contractually enforceable agreement between the parties that they will keep something confidential. You might not have even trademarked it. You might not have even looked at getting a patent. It's too early, but you've got an idea and you don't want someone to steal that idea. And it's really hard to keep secret, isn't it? How it could leak out. Any of my staff could say something. My customers could kind of get a hint what's going. My competitors could be onto me if they see that I'm testing something or know I'm out and about talking to people. The NDAs are really simple. They're 2 pages. And if someone breaches them, they've breached a contract. You can sue them for damages, and the damages could be significant. What you could have made if your idea had been yours to control. Uh, so absolutely, NDAs are great. We've got them here on the LawPath platform as a template for you as part of your subscription package. You can tailor them for your business. You are the discloser. You're giving the information to the recipient, and you can control what they could use it for. Here's the example. You could say, look, you're not my employee, you're not a contractor, you're a potential customer, or you could be someone who's looking at exploring a relationship. We're just talking about a joint venture at this stage, for example. I'm going to give you some sensitive information about my business, my customer lists, how many customers I have, my pricing, but also more importantly, how we do business here, the systems we use. Get them signed up to an NDA. They might ask you to have one too. We call them mutual NDAs, and there's nothing to be afraid of there. It means everyone's equal. Everyone starts on the same page. Everyone knows their IP is protected, and everyone knows where it came from. Avoids any type of argument. They stole my idea. We got there first. We thought they were sharing with us. We created it independently without their help. All these types of things. Absolutely. Showing someone any of your ideas, just see a little chat come up there. So if you're showing someone your graphic design ideas, your models, your concepts, what you think the customer might like as part of your quoting process, you might say, look, it's going to be hard to get a customer to sign an NDA when I'm just talking to them. I'm showing them brochures and other examples of my work. That's fine. But what if you move to that next stage? It's the mock-up. It's the beta version of their app that you're working on. You would want to have an NDA. But guess what? Let's go to the next slide. The NDA works at the beginning. And again, they're protecting the idea, but it doesn't mean the idea won't be used how it needs to be. So the people who've signed an NDA can talk about it with you or could talk with the people you say. It just means they can't disclose it publicly or particularly to a competitor. But the most important thing is once you've then got the deal or you're about to do a deal, as you can see here what they don't do. They don't replace the contract. So let's go to the next slide. Confidentiality clauses in a contract complement your NDA. So we would say the parties are subject to an NDA, but now that we're in contract, here are these even more robust confidentiality clauses. And some people say, hey, Chris, they're just boilerplate clauses. Don't even need them. Just take them out. They're really long and boring. I say, no, they're probably the most important clauses there, aren't they? Because it's protecting your most valuable asset, your IP. All right, let's go to the next one. Here we go. Now, you're going to lose confidentiality if you just publish it online and let everyone know about it anyway, aren't you? You can't say something's confidential if it's already out there. So there are exemptions. You can take something that's confidential to your lawyer, your accountant, your advisors, because obviously you need to do that to get advice on whether it's a good idea anyway. So most confidentiality clauses will have carve-outs for that. You might need to report a crime, or you might get subpoenaed. Things you can't control, which are subject to other laws. So obviously confidentiality doesn't apply if another law forces or compels you to do something. But other than that, if you want to give it to someone else, you have to get the party's permission, don't you? They might say, oh, that's fine, give it to your subcontractor. You need them to do the quote too. You need them to help you build up your design, as long as you've got permission. And of course, you'd be saying, subcontractor or independent contractor, we want you to sign the same type of clauses too. And this is all very different to trade secrets. They're old school. KFC's 13 herbs and spices, the Coca-Cola's secret formula. They don't even bother with any of this. They literally just keep it so secret and only let certain people know a certain part of it. They can't put it together. I mean, Coca-Cola even makes people take different flights, different people on trains, So they can't combine the formula, and it's actually been proven to be almost impossible to reproduce chemically or scientifically, and many have tried. But trade secrets only work because they're secret. So you could say, I don't need any of this, Chris. I trust the people I've told, and I'm relying on trade secret protection. Well, the instant the idea gets out there, it's not a trade secret. So in the days of the internet, the modern world, business, hacking, people getting your data without you realizing, it's not worth it. All right, next slide. Okay, let's go past. We're going to go to IP ownership. As I said, you can cut and dice IP however you want. Sell it, rent it, license it, lease it, whatever you want. But you can't make it up if it's not real. So it's got to be written in a contract what you actually decided to do. Are you allowing your customer to just obtain the benefit of using your IP for themselves? They bought your car. You made a car. You gave them a car. You gave them permission to use the car. They can modify the car, customize it, do whatever they want. But they can't go and reproduce your car and sell it as a mass car manufacturer, can they? But they can do anything else they want to it. You gave them those IP rights. Yes, you can modify it, you can tweak it, you can change the color of it. Of course, you own it, but you don't own the IP. So don't you dare try and reverse engineer it, commercialize it, or manufacture it. You could have all of those protections plus more. If you're selling someone something online, a course, maybe they're doing a training course, your business provides training, they don't own the content. That's yours, that's your copyright. But you give them permission to use the content to complete the course for their learning, don't you? But it's very limited. Once they've done the course, that's it. So you'll see some very cool language in IP clauses: perpetual, irrevocable, worldwide, royalty-free license to use something for a particular purpose. Those words are very important. And some people don't take the time to think about, well, when does my permission end? Or does it even matter now I've been paid? Okay, next slide. All right, you can see it's all about timing, clarity as to what, when, and also when it's withdrawn. So let's say someone posts that course content online or tries to copy your business model. You're going to revoke that license instantly, aren't you? You're going to go after them, sue them potentially, try and recover. But those licenses can be revoked at certain trigger points. For example, someone hasn't paid you their latest fee, their subscription fee, they're overdue. License is revoked. They can't use it anymore. Return all materials, delete all materials. You can absolutely have those things. If you're selling someone software and they use the software for an illegal purpose, that license is revoked. It's cancelled. And they've got to return and destroy everything. And you can compel them to do so. And there's court remedies available. All right, next page. Okay. Now, this is slightly misleading, and it's why contractors create higher IP risk. They don't necessarily create higher IP risk. It just means that IP should be it should be higher on your radar in terms of things to think about. Because you might need the contractors, you need their knowledge, experience, their skills. So you might have no choice but to go and get someone to make something for you or do something for you. But the key is, are they going to sell that same thing to someone else? Your business just paid someone to make your logo. Your competitor's now using a logo that looks pretty similar, and they got it from your same provider. You don't want that. Contractors make their money by basically selling their skills to multiple customers, don't they? But what if it gets a little bit too close to home and you paid them a lot of money to do all this work, and the next thing, someone else, particularly a competitor, gets the benefit of you having paid them to do it? They're just reusing things, aren't they? You're reusing things. Nothing's an original idea anymore, is it? Your customer gets the benefit of your experience. But how far can we take that? And the most important thing is, was it yours to give? Did your contractor sign a contract that said all the work they do transfers to you, the buyer, the customer? Did your customer sign that? That's where it's really important. And look, IP clauses get buried at the back of contracts. People don't read them. People don't see them. They don't think about it. They're like, I'm selling you a widget. I'm getting paid for the widget. Well, actually, I'm not. I'm selling you the rights to use this widget in a certain way, aren't I, for your benefit? So always talk about IP. Contractors won't bring it up because they're like, oh, it's fine. You get the product, you get the service. I commit to doing that. You're like, hang on a second. You committed to give me something, but what can I actually do with that? I don't want to have to pay you more, and I don't want to have to pay a license. So if you're in a relationship with someone else where you're adding something and they're adding something else, so let's say you were preparing some training material and you wrote the first chapter, someone else wrote the next chapter. You combine it all together and you sell that product. You're collaborating. Well, normally each of you would own the individual IP that you put in together. But sometimes IP gets blended, it gets mixed up, chopped up, pulled apart until sometimes it's really hard to tell who it belonged to in the first place or how it's changed. Background IP, contract material, future IP created. We haven't even made it yet, but what if I have an idea in the future to improve my product? What if someone else comes up with something that makes it better? They're my employee. I want to own that idea, but I don't know what it is yet. You can absolutely contract future IP and ideas as well. And that can help you to ensure that all the benefit of your product line or your business model stays with you as the ideas manifest or as the materials created, people doing their job day to day. Just having a quick look at this question here. This one is about if a company's registered their name and then someone else has obtained a trademark with a very similar name. When you try and register a business name, the Australian Business Register will actually look to see if someone else has a trademark with that exact same name. People say, hey, that's fine, Chris. I'll just call my company XYZ Holdings or XYZ Group. Then I'm not in trouble because that's not XYZ Proprietary Limited, is it? It's close. It's close enough. Well, maybe, maybe not. If XYZ Proprietary Limited is Amazon or Microsoft, they're going to have a problem. So again, it's the big fish, little fish, the laws of the jungle and the practical leverage around IP is just as important as the law itself. All right. Here's one. I like this. Something about Elvis. Here we go. Does Elvis's estate need to protect his TM? Oh my goodness. Elvis's estate sues more people than you. They are one of the most litigious estates around because so many people love Elvis and they just want to use it. They might want to play a 20-second clip. They might want to put a picture of him on something. Absolutely. They actively enforce their rights and they are incredibly aggressive about it. And they do it because they don't want Elvis's memory or reputation to be tarnished. The worst thing that can happen with unauthorized IP infringement is if someone uses your identity in a public forum and causes embarrassment or is offensive and causes reputational risk to you. It's not that they stole it and made money for it. It's just they used it in a way that's really damaging to your business. So absolutely, that is a really good point. So when something is very valuable and very popular and people want to copy it, next day you see it on Temu, it's on eBay, it's a knockoff, all those types of things. They've changed one word of your logo, but it uses the same color. People are getting confused and mixed up. They're buying a product they think's yours, but it's low quality. All of these things are very, very common. But enforcing is expensive. Going to court against a business which is overseas in China or India that's blatantly copying your IP can be really challenging. Getting injunctions, shutting down their website, all of those things are complicated. They can be done, but it's not easy. So the most important thing to do is be real proactive, to be stomping around like a gorilla, letting everyone know that it's yours and you're going to do something about it. So here's a little tip. If you've got your brand, you'll see a lot of people will put a little TM next to it, which means trademark, doesn't it? That doesn't mean it's registered. That's just a flex. That's the Temu version of pretending you've got a trademark. A trademark is not official unless it's registered. And when it's registered, you get to put a little R in a circle. So when you see a brand that's got a little circle with an R on it, you know they're pretty serious. They spent the money and they actually registered their trademark. If you see a brand that's out there and it's got a little TM next to it, they're not really serious, are they? They're kind of pretending they've got a trademark, but they don't actually have one. All right. So obviously things change when you're dealing with your customers and your suppliers. You know, people have ideas in different ways. People produce things of different time frames, and the relationship might change. You might buy them. You might sell to them. They might become integrated with you. You might merge. You might do a joint venture. Where on earth is the IP? Which company owns it? Who owns it? Is it in my head? I'm a sole trader. I'm a sole trader, Chris. How do I register my IP? Same way as anyone else. Oh, Chris, I've got family trusts. I need to defend my IP by putting it in an IP holding company. So if someone sues me or I get wound up or I'm bankrupt, my IP is not available to my creditors as an asset. Absolutely. There are so many ways we can help you protect your IP, make sure it's sitting in the right place and that it's available. There's all kinds of tax hacks you can do. Here we go. I set up an IP holding company, XYZ Proprietary Limited. I licensed that to my trading company or my business company for $1 a year. Or I change the license fee depending on my sales or my profitability or whatever I want. I can move revenue back and forth between those companies as an IP licensing fee, can't I? So many permutations. And our tax team is all over it. Now let's move on to AI. AI. Everyone uses it. If you're not, you need to. It's there. It's not going away. IP. AI. It's copyright. It's that 500, 600-year-old law trying to adapt to the digital world and failing. This is one of the most hotly contested, most litigious areas. Claude, ChatGPT, all the big US software vendors and large language model providers suing each other to pieces over all of this. Who owns the content that AI produces? Who owns the data that AI is training itself on? It's just hoovering up the entire internet, isn't it? Isn't it too late? How do I stop it? Hey, I just produced some content for my website, or I just produced a newsletter or a blog or an email. It wasn't me. I just put a prompt into AI and just came out with something. Is it mine? Do I own that? No, you don't. Copyright doesn't work with AI because it wasn't produced by a human with creative effort, as in intellectual output from a human being. Telstra tried to copyright the phone book, the Yellow Pages. It was a very famous case. And the court said, you just used a software program to literally create an enormous list. No real intellectual or creative output there, is there? No copyright for you. But then someone said, hey, I wrote an AI novel. I chose the characters' names. I told it what would happen. I put in a lot of work. Or, hey, I just prepared a visual design for my customer, but I'm the one who gave it all the instructions. I wrote pages and pages of special conditions and then put it into the AI. The AI is a tool, isn't it? It's just like a builder with power tools. Yes, you could hit the nail in with a hammer. It's a little bit harder, a little bit slower. Or you could use a drill with a screw. Isn't the AI just the drill? I decided how to do it and I decided when to do it. So there's a lot of tension there around, isn't AI just happening faster, but it's still the input, my prompt, what I'm typing it and telling it to do. Now, there's been a lot of cases where that's been tested, particularly in the software space, where someone's writing code and they're using AI to assist them to fill it in. And yes, in some cases, there have been situations where the author can prove that they took that extra step, that creative spark, that inspiration, which used the tool to create something truly unique. But very few people use AI for that. They're just using it for everyday answers to questions, producing basic documents, designing things. And it's a real grey area. In Japan and the UK and the US, there's really no protection for AI. If you type that into your AI, it goes into the data set and it can be reused, cut and diced for the benefit of any other person. As I said, there's no new idea, is there? It's just recombining pieces of other content. Now, those countries allow it because they're so pro AI. Australia doesn't have that. You actually have to get permission from someone to use their data or their copyright to put it into your large language model, or to put it into their AI. And they're meant to pay you a fee for it. No one does. So the laws of Australia still seem to think that we're dealing with a situation of someone's physically printing a book, and we're dealing with a copyright in terms of who owns the book and then who can read the book. But AI, things are moving so fast. So it's certainly something that you will use in your business. And in terms of protecting it, once you've produced that AI product, you're putting your brand on it, you're putting your trademark on it, you're putting your logo on it, you're putting it on your website. Make it clear that it is yours. If it's in your email, it's got to be branding on it for sure. But if you know that that came from you copy pasting in something from your competitor, be prepared for your competitor to notice. They often use AI tools to track this, to actually search for content that's been infringed. Lawyers use it, the courts use it too. So it's one of those things where I always say to people, use your professional judgment and imagine how you'd feel if someone else just stole your content blatantly. Yes, you can use it for inspiration, but put in the effort to make it something that's yours. Now, in terms of disclosing, do I need to say that this was produced by AI? No, you don't. That's not a legal requirement. As long as someone's not deceived into thinking that it wasn't yours or yours to give, then it's okay. But of course, people might not be happy if they find out that it was AI. But then again, people buy products and services all the time which are created by tools or processes that are fully automated. So it is the reality of the world. Some businesses, some companies, some funders, some investors don't like you using AI, or they'll ban it or they'll put conditions. And you know why? They invested in you and they paid you, but they don't know whether you own the thing they invested in. I would not want to invest in a company that produced an AI product. I would want to know I own that AI product. That's why I invested. That's why I bought shares. So that's why it's important to be able to tell your customers or your investors or your business partners what is actually yours. If it's the algorithm that goes into the AI to produce something, if it's mathematical models, then absolutely, you still need to explain it. Don't just give them the artifact and say, I made this. They want to actually know how. All right, let's go to the next one. All right. You will see secret clauses at the bottom of your terms and conditions when you try and update software on your device. You just click it because you want to use your iPhone, don't you? But they have all these things where you're giving them permission to use any of the content you create, that you're giving them permission to do data mining and sell that information to others. So privacy and data it's like two sides of the same coin, isn't it? Really, they're inextricably linked. Always a question about rights to use it, who owns it, privacy and data go together. So privacy policies, consent, as well as how do we use the data are important. And at LawPath, one of the biggest challenges that we see clients are facing is how they're managing their customers' own data when their customer gives them something, not just their personal information like their names and dates of birth and things, but gives them their own idea or something they thought of. Here's a little mock-up of what I want, or here's an email with my thoughts. How do we integrate that into your systems, protect it, make sure you can use it for the purpose, so that when you give it back to them, they don't say, I'm not paying because that's my idea, you just used it. All right, next slide. Okay. I wouldn't be a good lawyer if I didn't tell you to do something at the end of this. Um, Obviously, it's proportionate, isn't it? You can worry a lot about these things, or you can just take measured, balanced, proportionate steps to protect your IP. And of course, the most important step is just knowing what IP is yours, or knowing what IP you're using belongs to someone else, whether you're borrowing it or licensing it. No point having a contract with someone where they can turn the IP off straight away and you're left with nothing. So doing a stock take, doing a current state assessment of the IP you use in the business and the IP that you're producing is a really good idea. Next thing is, do you have contracts for it? A lot of people don't even have contracts for that. They say, I've got a sales contract, Chris, or I've got a purchase order. And I often say, okay, so show me where the IP is moving, show me the IP flow, or what we call IP leakage. And they don't have anything for that. So it's really important to put that front of mind in your content, in your contracts. Then the next one, which is, people coming to you, make it clear to them what they can and can't do. How can they use your website? What can they do once they've downloaded something? What can they do when you've sent them their product and shipped it to them? And then, of course, full circle, back to the start, register that trademark early. Now, we've got a really good system here at LawPath in terms of how we manage your trademarks and your IP portfolio. We do patents, we do design rights, we do circuit layout, which is another form of IP. We do plant breeders' rights. We have clients who grow plants, create new varieties. That's all part of IP protection as well. It covers any type of industry, any type of sector, but it is a very arcane area of law. As I said, it's very old. It's very poorly understood, particularly patents. So we can certainly help you with that. And a lot of it, you can use your existing subscription and services that are available to you at very low cost in a repeatable way. You can use a template that we have to assign your IP, to make sure your employees have transferred it to you. You can use our software licensing templates to do all this. It's all there. It's just pulling it all together. And let's go to the next one. So we call it an IP health check. It's just like you go to the doctor. No one wants to do it. The doctor tells you to do something. Maybe you do or don't take the medicine. That's fine. It's always your choice. And you know your business best. But the first thing I always tell people in the digital age to do is just check whether or not you actually own your logo, your website, all those things. Do you have the domain registered? Do you have your logo locked down? Do you have those words, the word, the name? Do you have contracts that are up to date and enforceable? Have you got your NDAs stored somewhere? You've got copies of NDAs. You've got a process to make sure everyone signs them. NDAs can be signed online. It can all be done digitally. Everything I've said about contracts here can be done online on someone's computer or their smart device or their phone. We're not talking about giving someone a 50-page document to read through and sign and putting them off the business from the start. Integrated with all your other workflows. And then as for AI, when you're using AI for your business, and I'm not talking about your own personal account with a Gmail or a Microsoft, I mean when you've actually signed up and you have an AI product which is connected to your business with APIs or is connected to the back end of your system, like for stock and things like that. Just keep in mind that more than likely, unless you've changed the settings, all of that data is available to the AI provider, goes into their large language model, and literally can end up anywhere used by anyone else. All right, next one. Okay, so my takeaway is that if you can't answer straight away what your brand is and who owns it, if you say, I own the company, it's mine, I set it up, it's mine, that's not the best answer. You need to be able to say, hey, I've got a trademark registered and here's the registered trademark identifier. I've literally got the piece of paper that shows I own it. And it's not just me saying it. It's the same as the title to a house. It's on the National Land Titles Register. This is with IP Australia. Other people can search this name and they will see that I own it. And a trademark is valid for 10 years, which is more than enough to protect you during the early stages of your business. And they can be renewed, absolutely. And of course, if you've held that trademark for 10 years and you go to renew it in the 11th year, no one else can take it off you. Someone can't come in and say, oh, they've left it too late, they forgot to renew, it's mine now. No, if it was yours, you get the first right to roll it over for another 10 years or more. Same with all other forms of IP. Okay, well, Barry, I think I've covered everything that's in our slides for today. So if there are questions, happy to answer some now, or otherwise, over to you, mate.
Yeah, no, definitely. We'll go through the questions in a second here as well. LawPath's able to help with, IP protection, advice around it, everything like that in quite a few ways. We work with, ongoing kind of legal support for new businesses, small to medium businesses, everything like that. So ongoing advice, unlimited consults with lawyers, access to all the legal documents there as well. If you could go to the next slide, please. Um, so we can also help with, custom contract drafting and reviews as well. We help with, as I mentioned, kind of the legal document templates. We have over 500 legal documents on our platform, all drafted by Australian lawyers. And you can also kind of get that free legal consult there as well as like an initial kind of experience with LawPath and seeing how we can help as well. From there, as I mentioned, we help with contract management for your business. You can create personalized workflows through our platform there as well, and booking in those unlimited legal consultations to just be able to, have that constant support and advice throughout your journey as a business, whether it's setting up your business, protecting your IP, hiring employees, everything like that, just making sure it's all done correctly throughout that journey. For everyone that has attended today, firstly, thank you very much for attending. It's been a great experience. Thank you, Chris, for running through everything there. It was very, very insightful. For everyone that has attended, we're offering 20% off our legal advice plans as well. So that's where you can get those unlimited 30-minute consultations with lawyers for a full year. We do on-call reviews of your documents, contracts, everything there too, and general kind of advice as well. And you can also use our live chat to chat with lawyers or accountants for kind of smaller bits of advice there too. So from here, we'll jump into our questions and answers. Um, First question was, if you own a trademark, do you need to be seen to be protecting it, or can it be lost? For example, does Elvis Estate need to protect the trademark often or risk losing it? Chris, if you can answer that one there.
Just say that again, Barry. I didn't quite hear that, mate.
No, no problem. If you own a trademark, do you need to be seen to be protecting it, or can it be lost? For example, does Elvis Estate need to protect the trademark often or risk losing it?
Yeah, so look, it's better if you can prove you used it and relied on it. One of the ways that trademarks can be open to attack by a competitor is a period or a failure to use it. You register it and you've never branded anything with it. It's sat in the cupboard, it's gathered dust. Clearly, you don't intend to use it. But hey, what if you're building something that you're going to launch in a few years and you wanted to get in early and just have that trademark ready? That's totally fine. I've got clients who register many trademarks, but then decide what they want to call their product or when they're going to launch it. And that's absolutely fine. They've done the right thing. The only time someone will get you is if you don't have a trademark at all and you weren't proactive enough to show in the market that you were using and relying on it. Now, a good example is two businesses with a similar name, neither of which has a trademark, both upset with each other for pretending to be the other one. One says, my business is older than yours and I've been using that name for longer, so it's mine. Yeah, no one's got a registered trademark, so that's not going to fly. You can prove that a trademark shouldn't have been granted, as in you can oppose a trademark. If someone tries to register a trademark, you can actually apply to oppose. That's why it takes 7 months for the government to process it, because they're inviting people to come in and say, hey, don't give them that trademark. That's my name. I've been using that for 20 years and I'm a small business in my town. Doesn't matter if they're a big international company, that's mine. And I have clients who have owned small businesses in Australia who have absolutely um, crushed big international companies who thought they could come to Australia and use some Australian word or phrase that had actually been used by someone else back in the days, before the internet, TV commercials and, mail drops and things. So yes, but you have to prove that you were actively using it, you relied on it, and people know what it is. But then again, there are people who invest in IP and keep it secret. So let's say you were a carbon intensive energy company, and someone came to you with an idea for cold fusion, or something that was incredibly environmentally friendly. You might buy that and then pivot your company and sell it yourself, or you might just put it in a safe and keep it secret forever because that's a massive threat to your business. So IP can be used for a force of good, but it can also be weaponized in terms of stopping a good idea getting out there or affecting you. So if you see someone who's got IP close to yours or using a name like yours, and you don't want them to, you can buy it. If they want to sell it to you, or you can force them to stop using it. So there's lots of different ways to do it. You can acquire by dominating and purchasing and tying it all up, or you can fight it fairly and publicly using the legal system. But there's commercial leverage involved, isn't it? As soon as someone finds out that you want it, the price probably goes up, doesn't it?
We also have an Australian citizen here that's currently living in New Zealand. They have started a business in New Zealand that they're looking to potentially protect here in Australia as well, wanting to know the best way to kind of go
Oh,
about this.
absolutely. So if you've got a trademark in New Zealand and you say, hey, I want to use that same brand in Australia, the good news is there's that Madrid Protocol treaty I was talking about. So you don't have to go through the whole process of applying in Australia, getting your trademark approved. You can say, hey, Australian government, I've got a New Zealand trademark registered under the same treaty you use, and I would like for my trademark to be recognised in Australia. Now, for a very small fee, I mean, there's always a fee, isn't there? The Australian government will say, absolutely right, totally get it. Come and we'll put you on our list too. So it's much faster and easier. So some people get their trademark in their initial market or the country they're from, where their business is from, and they expand globally. Some people try and trademark in all 146 countries that are party to this treaty all at once. Now, that's very expensive. But again, if you're Toyota or a massive listed company, that doesn't cost you much. That's nothing to you. Of course, you're going to do it. If you're Sony and you're releasing a movie, you're going to do it. So yes, you do see trademarks popping up all over the place, sometimes all at once. But the good news for you is it's not going to cost you much. You've already done the hard work. Um, and it will be very easy for you to get that brand across and protected in Australia, just like you have in New Zealand.
Awesome. And then how would you describe an IP holding company within a business structure?
Oh, very easily. So let's say you've got an existing business, could be a family trust, corporate trustee of a family trust. It could just be a private company, proprietary limited. What you'd be doing is the IP that's sitting in there at the moment just needs to be assigned or transferred to a holding company. We call it a shell company, a $2 company. It doesn't own anything else. So its shares are worth $2, but it's got the IP. That's the asset. We do a deed of assignment to transfer that from your current company, get it out, protect it, get it away from creditors, get it away from competitors or anyone else who means you harm. So if they sue you, they can't get your IP because you don't own it. You've just got it under license from your holding company who's over here sitting pretty purely protected and has no other assets either. Same directors, same owners, same control. And you just do a little licensing agreement to send that IP back. If you've got a lot of companies, you can have subsidiaries that all benefit from this too. And the good news is you can control which way the IP goes. Your main business will take the IP and improve it, constantly creating new things and using it. Well, guess what? All that IP, the new stuff, the new designs, the enhancements, flows automatically back to the licensor, which is your holding company. So you didn't have to think about it. That holding company always owns your IP. Anything new that comes from it goes back to it, back into the safe and protected. Very easy
Cool.
to do.
And would you need to apply separately for a trademark for the name and the logo, or can you do them at like together
Either
in one?
or. You can go for the word mark, just the word on its own. You can go for the logo mark, which is the word and the symbol or the picture or something like that, or what we call a logo. Absolutely. As I said, um, because logos are figurative, as in they can be anything, symbols, colors, shapes. They're easier to get because you can make them so distinctive. A word, what you're actually trademarking is the word, not how it's written. So not fancy italics or fancy shapes like you're just trademarking the word. Um, so the very first trademark in Australia was actually for a form of cough medicine, and it doesn't exist anymore. But it was a completely made up word. It didn't exist in the English language. So it was easy to get that because no one else used it. But sometimes people are using words like Uber, which does have a meaning in the English and Germanic languages, but is also being used to describe something completely different. And Uber is trademarked, isn't it? Now, that's the word Uber because it's so distinctive in the way they use it. But it's not the way they write it, which is stylized. They also have a logo mark for that.
Fantastic. Here's another one. So, how would an SME attempt to prevent a situation like the big fish example shared in a global market when certain jurisdictions won't grant formal IP protection until you're trading in that market? Say an Australian brand has protections in Australia. What stops a big fish US entity securing the Australian brand name in the US before the Australian brand has the chance to commence trading in the US and securing US protection?
Okay, so this comes down to the principle of deterrence. How much is it going to cost them to do it the easy way or the hard way? Yes, you are a little fish, David and Goliath. There's that kind of analogy, but it's going to be hard for you. As a little fish, you don't have the money to sue them. You can't go to another market, try and enforce through the Chinese, Vietnamese, Thai legal system. Um, and keep in mind, in China, if you try and pursue trademark infringement, they have a 10-year wait time, and 90% of the judgments are in favor of Chinese companies. So you look at that, you think, well, what's the point, Chris? How am I even going to bother with that? So it's practical, isn't it? What is the cost going to be to your competitor to take you on? Now, you can bleed them. It's the death of a thousand cuts. You can delay them. You can lock them up. You can cause them reputational damage through the legal system. So basically, you want them to look at you and go, they're not going to be easy for us to take on. They've got everything registered. They're very visible and very vocal. Let's find an easier target. So I always say deterrence is the cheapest way of dealing with legal risk. So yes, you might, if you had to, marshal the resources and the money to take them on, but it would break your business. And this other entity, they've got money to lose, money to burn. Samsung and Apple spend on average about 50 million US dollars a year, and I've acted for Apple in this, so I've seen it, suing each other for stealing each other's patents for their phones. Now, they steal each other's tech, don't get me wrong, and that's part of what they do. But then they just go and sue each other over it simply for the sake of making the other company spend money. And it's a bit of a joke. So, these are two giants just slugging it out, completely pointless, both guilty of doing the same thing, but they've got the money to do it. But that's, not something anyone wants to really have to do. So you make an offer. Hey, look, you really want this. We're for sale, but this is a big price. Or you say, you know what? We're going to just fight you and we're not going to let this go. This is our brand, this is our identity, and we are going to constantly go after you. And you're just going to get so annoyed with us. You're going to hate it, and we're not letting go.
And then another one here. Do you need to trademark your own name?
No, no, you don't. So if you're a sole trader and you're Chris Heaton, you can call your business Heaton's Lawn Mowing. You can call it Chris Heaton. No one can take that away from you. Now, if there were a lot of Smiths and it was Smith's Landscaping, Smith's Lawns, Jim's Mowing, then yeah, it can be a little bit of a problem when it's so distinct. A lot of brands from the very old days, as you know, were just named after their inventors. So you'll see lots of products around today where it's literally the last name of the people who invented it, but it's become so well known now that you just can't take them on because it's so distinctive. So history helps, but if it's been in your business, in your family for generations, and you've used a family name or something that's got an attachment to you, like where you're from, where you're born, where your business is, or things like that. Like if you were saying, North Coast something, or if you were saying, um, a geography name was describing where your business was, then yeah, that can absolutely become distinctive. But as for your name, you don't need to trademark your name, but you do need to register the business name, don't you? So a lot of people say, I'm a real estate agent and I sell through my name. So the brand is me, the person. So if I'm going to call it Heaton's Real Estate, um, I don't like the idea of someone else having a business called Heaton's or Hayden's or something similar sounding. Now they're going to say, that's my name. I can use it. Absolutely, they can. But if their design and their logo or anything else looks similar to mine, then we can absolutely go after them.
Awesome. So another one here from Jean saying, thanks, Chris. Another question. When preparing an NDA ahead of potential business relationship that doesn't progress to formal terms, is it reasonable for the NDA to be open-ended time-wise, or is it best practice for NDAs to include a defined time period?
That's a fantastic question. I really like that. How long does an idea stay alive? How long is the IP alive for? Indefinitely, forever, it's perpetual. So the fact that you're talking to someone about something, they can remember that or try to use it again in many years. And I've been involved in many cases where people say, oh, isn't it just 7 years, Chris? I can put a clause to say that they have to keep it secret for 7 years and then they're free to do it. No, it's perpetual. They can never use it. So an NDA shouldn't have an expiry for keeping that secret. Now, in the passage of time, people die, people move on, people forget. So time cures a lot of this anyway. The people who knew don't know anymore. But if it's in a digital format, which most things are these days, and you sent it to them in an email or they downloaded it, it is there forever. So the NDA needs to be able to reach back and protect that forever. So you should definitely have that. The only time you'd have a time frame for something like this would be when someone could make an announcement about something. So say you developed the product together and you were launching it, and you wanted to be really careful about who said something first or who told the world that it was created or coming into existence, like building up the hype, if you know what I mean. You deal with that through a different consent clause, which sort of says, subject to our NDA, neither of us can go and make an announcement to the market without us both agreeing on when to do that. And that's to stop, a more enthusiastic business partner accidentally letting the cat out of the bag.
Fantastic. Thanks for answering that one, Chris. So we have another one here. If your business is involved in both services, consulting, and product development, then would it be better to have this holding company and operating company structure and having the holding company own product IP and license the IP to the operating company?
Yeah, yeah. I mean, either work. I'm a big fan of keeping it simple. So the operating company should be doing the work and getting paid. The IP should effectively just be sitting above or alongside them. So you can actually have IP in different companies. And some people say to me, Chris, well, I feel like it makes more sense if the company owns its own trademark, yeah? Because if the company doesn't own its own trademark, it can't really control it. And if I want to sell my business to someone, they want the trademark, don't they? So how do I get that across to them? Or I'm going to retire, or I've got a family member taking over, but the IP is in my name or in a different company. How do we get that all to the right place? Well, you can absolutely transfer the IP and assign it, but absolutely, if you were selling your business and the person wanted to keep that name and keep that logo, um, we might say to them, well, you can buy the company group, you can buy the whole structure, you can buy the company, which is the IP holding company, and the company that operates the business. That's fine. Then they get it all. But you might say that's not going to work because the IP is sitting in my family trust. I've got a corporate trustee that's got all my tax concessions in it, all my tax. I'm not giving that to me. I'm not selling that. And they don't want it either because they don't want to take on historical liability. So they might say, we want the IP asset, but we don't want it in the way you've got it set up. Totally fine. I see that all the time. We just do a little transfer of the IP separately. So it's in a contract for sale. Absolutely. But again, I've seen what's called a 7-step IP holding company where there's 7 entities interposed between the operating entity or the trading company and the ultimate beneficial owner of the IP because they're in multiple countries and multiple markets. So it can get very complicated, but most people just like to have one step, one connection.
Yeah, and so obviously there are, many overseas providers of graphic designs, etc., services. If we do a contract for assignment of IP with them, is that sufficient protection?
Yeah, so if they're overseas, the key is you want the contract to be subject to the laws of your home country or the jurisdiction where you know you can enforce it and has a legal system you understand. So if I sign an agreement with a Chinese company, a Filipino company, and a Southeast Asian company, and it was subject to the laws of that Southeast Asian country, I'd be very concerned. I don't know what the laws of that country are. I'm not going to really get very far as a foreigner in their court system, am I? What's the cost going to be? How am I going to leverage them? They control, they set the rules. So what I want is the ability to go to an Australian court and sue them here and get that judgment enforced in another country because I know the costs, I know the law, and I know the time frame. So if I have the power and the leverage, I'm going to say to that overseas provider, here's my contract I want you to sign. And you can see it's subject to the laws of Australia. That's where I'm going to enforce it. Yes, there are laws in your country which might say or do different things, but we're agreeing contractually that if we're going to argue about this or something goes wrong, it's Australian law that's going to prevail. Now, big fish, little fish, as I said, you've all got computers and you've all got Microsoft Word or Office, whatever, um, subject to the laws of California. If you looked at that software agreement when you downloaded that software, it will say subject to the laws of California. Now, anyone who asks Microsoft to change that to Australia will be laughed at. Yeah, the laws of California are designed to be pro-business and pro-Microsoft, full stop. But if you have the power to turn that on its head and you have the leverage, or they need you, or you need that, then you should absolutely say, I want it subject to the legal regime that I know and understand and can operate in. And also, if I'm giving you my Australian trademark to use for something, so if I'm licensing it to you, I want to be paid in a way that makes sense for me. I want Australian dollars. I want it done in this way. You can absolutely set those terms. Now, if they come to you and say, in our country, the law says you can't do that, the first answer to that is, well, that's unusual because IP has been licensed for about 500 years. The concept was invented by the British through the UK. Australia, as part of the Commonwealth, inherited their legal system. So we kind of made this system, like this is the system of our design. So if you come from a different legal system, which might be a continental legal system based on French or Spanish law, which has different concepts of property law, then absolutely they'll be completely opposed. So that's when you need to go through very carefully and work out how to reconcile them. But most businesses, particularly in the Asia Pacific region, use either a US, Australian, or a UK contractual model and concept of IP. There are some countries like Nepal where you can't own IP. There is no IP. It cannot be owned. They have a different concept of property, and their legal system prohibits someone from copywriting or trademarking anything. They just do not have that. They still do business there. They still operate and they're still connected to the world, but it's just a completely different concept. And some countries have, degrees or margins across the spectrum for that.
Awesome. Thank you very much, Chris. We are going to have to end it there just in the essence of time. Thank you very much for everyone joining. If you do want to kind of carry on a conversation or have a conversation around how LawPath can, help with IP protection or any other area of your business, please type yes in the chat. Be happy to give you a call and see, how we can help and where we could be a potential fit for you. In the meantime, again, thank you everyone for joining. Thank you, Chris, for going through everything there and answering those questions. As I said earlier, very, very insightful. And you obviously know your way around IP law there as well with all that experience that you already have.
Thanks very much, everyone. It's lovely to have you all on board, and I hope that was helpful in some way. And look forward to seeing you at the next one.
Awesome. Thank you all.
Thank you.